I did something new. I pressed go live on a schedule. So did it not let you in? Because I couldn't see you beforehand. Okay, note to self, don't do that again. But look, good news. We haven't broken anything, I don't think. Anyway, welcome to the 60-minute clinic, an incredibly amateur broadcasting hour of me, Ursula Rice, and Maria, who we both work at Family First Solicitors. Me working all the time, Maria working all the time. Maria's on her journey to become a chartered fellow, qualified litigator of the Institute of Legal Executives. They really need us. It used to just be Filex, Silex, and they should have kept that.
It used to be, yeah.
Anyway, Silex, Filex. That's what you're working on your journey to become. And I apparently am a solicitor and a solicitor advocate. Still not sacked. So, cool. Anyway, I was musing today on the fact that being a solicitor allows you to certify documents. Well, not certify, but to take oaths and what's it called? Commissioner for oaths.
Mm-hmm.
And we get a lot of people, don't we, asking us to do that. And normally I'm supposed to, there's an official charge. You're supposed to charge £5 per document and £2 per exhibit.
Mm-hmm.
Everything that goes with the first document. So you can sort of make £7 and up on any given day per document, per swearing. And we give all our stuff to fees, and I reckon to charity. And I reckon we probably, I don't know, how much do you think we raise for them every year? Just doing that.
I reckon it's got to be in the region of about £100 plus, I would have thought, because you get quite a few come through during the course of the year.
More than 10.
Yeah.
200 quid?
Yeah, I think that's probably about right.
Yeah, I would say so. I'm slightly minded to change our charity because we haven't owned them for about 100 million years. So if the Barnsley lot, single parent support, want to get in touch and send me, what we need is a piece of paper with some QR codes on it. That's the magic. Because when the people come in, like all vague, we go, point your phone at that and tell them it's from Family First. And so I'd be down for our friends in the north who've helped us very much over the years and promoted this page. I would totally be up for them getting the goodness of what are known as swears, solicitor swears. So yeah, and I make people pay at least 10 quid. So it's a £10 donation, if not more. If they've annoyed me, then I make them pay 20. So, or rather not pay. But also it stops me having to raise an invoice, which is a complete win.
Yeah.
Anyway. So anyway, that was my little muse of the day. Whether that was very sensible or not remains to be seen. Anyway, have you had a nice day, Maria?
It's been another busy day, but it's Thursday, so you know.
Oh, you've frozen.
Oh, have I?
One of us is freezing. Oh, bloody hell. We're all freezing.
Yeah. Are you there?
Yeah. Is this real-time nodding?
Yeah. Real-time nodding. Okay, cool. Yes.
Real-time nodding. Very good. Very right. Why don't you read out the question? Because we have got some.
We do.
Do we need some code names? What were we doing?
Yes, we do.
We were doing, okay, we'll have to do characters in Dickens because I'm reading A Tale of Two Cities still. So, Charles Darnay. There you go. Call it Darnay, Darnay.
Darnay.
So you hand out a code name because that's obviously the hero. He's a bit wet, actually, in A Tale of Two Cities. But it is a good book, and anything about the French Revolution is fabulous, of course. So,
of course,
yeah, of course. All right, pick one and call them Darnay, and then read it out. Let's see. I daren't click more than one thing because I'll start freezing and doing the roundy thing.
Okay, let me just have a look and see what we've got as far as ones that need We've got some that have got a code name already, but
okay, we can do one of those. That's all right.
Okay, so if we do elf
on the shelf, yes, Nicola, send me something with a QR code. We'll stick it on the wall, and then you can have the money.
code name still Elf. Okay. So Elf says, this is kind of an extension of their previous problem.
Okay, we need a bit of background then.
Yeah, we need a bit of background. 1 second. Let's just
give us a resume. We don't have time to go back and read people's
old
answers.
Yeah, exactly. So okay, so okay, 1 minute. Perhaps this is just additional information from a previous question that we'd already answered, actually, looking at it.
Alrighty.
So
okay.
Yeah, we'll
come back.
Yeah, well, yeah, we've already dealt with that one. Okay. So what did you say the code name was? Sorry.
Darnay, Darnay. Let's give them a now. If you're watching, going, what the heck? Then obviously we don't read out people's very, very sensitive family law malarkey and use their name. That would probably breach like a million laws.
It would.
We'll start with GDPR.
Yes, let's start with the GDPR.
Go all the way, probably something about harassment, defamation, through to breaching, I think it's the Administration of Justice Act, which says, I think, I'd have to go and look, which says...
Especially if they're in proceedings, right?
Mustn't talk about proceedings, exactly.
Yeah.
So I think that's got something to do with it, but it might be also linked back to the Children Act. Anyway...
Okay, so
Darnay, so we can use your code name to answer your question, and then we're talking about you, and we know we're talking about you, but nobody else out there knows that we're talking about you. That's the point. Yep. And you get the code name in the DMs. So once you've sent a question or said hello, we'll get round to giving you a code name. But literally, this is amateur hour, so it's as shambolic as it is. Yeah. Right, what's the question? Darnay.
Okay, so the question is, I have a question about my ex who I share a mortgage with, but he has moved out and lives elsewhere. We are trying to sell the house, and he's saying that next month he will no longer pay towards the mortgage. We had 6 months interest-free payments and then moved to a standard variable rate. He's aware I can't afford a hit on my credit score, but also can't afford the payments. I don't know what to do. Okay. Okay, Darnay, I'm guessing you are not married. Are you married? That's an essential question for that. And we'll come back to you. So I've got another new questioner. So code name Ebenezer. Okay, that's my easy one. It doesn't mean you're Scrooge. It's just the first thing that comes into my head. Ebenezer. Okay, Ebenezer, your question is this. Oh, it's a long one. Right, Ebenezer. Ebenezer says, morning. Obviously asked this morning. Please could my query be asked tonight in tonight's 60-minute clinic? Your wishes are command. I received an email from the court yesterday confirming that a family court application has named me as a respondent. I was expecting this email as my daughter's father and I signed the consent order for contact arrangements in February this year. It wasn't something I thought to be necessary, as we have had the existing informal agreement in place for over 4.5 years, but he was insistent. I've just started to have a look at the many attachments in the email, and there are a few incorrect statements in the C100 form. Pausing there, everybody, to remind us all that the C100 form comes from the applicant, so isn't a document that is in and of itself the thing that is right about everything. It's that person's version. So firstly, it states we didn't attend a MIAM relating to the contact arrangements. We did, both separately, then together. Secondly, it states that the reason we should be exempt from attending a MIAM is that any delay may risk harm to the child. I wondered if there may be an additional inaccuracy on the section that asks if the children are known to children's services. There have been 2 separate children's services investigations, 2017 and 2021, and in both cases the father was told to have no contact with the children or myself until the investigation had been completed. The referrals were triggered by a disclosure at school and also to myself. The second incident was referred to the police. Should this be disclosed in the C100? Lastly, Is it possible that my daughter's father thought I may not be forwarded a copy of the C100 form, or is it made very clear that I would be? For context, he has PR for all of my 3 children. There's a 9-year-old who's his, and it's mostly about her that we're talking about. My 14-year-old is not his. PR was obtained through court in 2015, and the consent order just says he can see him if he wishes. He's had no contact for 4.5 years. My 16-year-old is not his, but PR, again, obtained through court in 2015. Consent order states dad and daughter can see each other if they wish. No contact for 4.5 years. Thank you for any support offered. Ooh. Okay, well, my take on this, my overriding take on this is be careful what you wish for. I think it's quite right that your instinct is we did not need this kerfuffle, this consent order kerfuffle. You can now get consent orders about children arrangements. They are very unusual. Have you ever dealt with one, Maria? Have you ever done one for a client?
As in just written a child arrangement order?
Yeah, by consent that you go and get to the court, even though nobody actually wants to issue proceedings.
Not yet, no. It's been in discussion, but then it ended up going to court.
Yeah. So this is the thing. I think the dynamic around the idea of a consent order for children is actually in a way that's positive. It's quite unusual. Normally it's being discussed in a negative connotation because the threat is, if you don't, I'll take you to court. And I think that's used as a stick to beat often women, sometimes men, I suppose, with, because it's the terror, the fear, the OMG, what if you get dragged to court, and what if, because of course as soon as you go to court you realize you don't have the balance of any control anymore, and what you might have sort of managed to catch and fudge is all up for grabs. And you suddenly hear, you hit Facebook, you hit the internet, and blimey, your world and mine is blown. So I think unlike financial matters where a consent order makes complete sense, it somehow doesn't. And I also think it slightly commercializes people's thinking around arrangements. It's like, well, I've got it in an order, so that's like a thing to me, that's a point to me, that's a duty that you've got to do for me. And I think, there's multiple layers of control in that, aren't there? So whilst I think it was a concept that was given out with the best of intentions, I have never found it useful. I've never advised a client it would be useful. And it's always done in a sort of brinkmanship kind of vibe. So that's my big fat take on it. And so you were right to be wary, but we are where we are because now we are under an order. The consent order is mostly about the 9-year-old. And your first question is, do you think there are inaccuracies? And I think you're right. If you went to a MIAM and then a joint mediation meeting, then he's just got that wrong. And the idea of not going to a MIAM because it creates delay for a child, well, the very essence of a MIAM is because it would take you out of the court system, which would stop there being delay for the child. So it's what do you call a thing that is, it's axiomatic that a MIAM can't be a bad thing because of delay. Those two things couldn't fit together. There you go. That's a great word. Axiomatic is one of life's excellent concepts and words. And I had to look it up the other week, and now I'm using it really quite often and being annoying about it. And if anybody wants to know the proper definition, go and look it up like the rest of the world, like me. But that's sort of what it means. It means it's like a central truth that we all know to be true, that, like, I don't know, that the world is round-ish. That's axiomatic. So it's the world is roundish, definitely not flat, that MIAMs can't be a cause of delay for a child. What was the last question? The last question was, do you think, yeah. Yes, sorry, the second to last question was, we had a bunch of children's services investigations, and
That sounds to me, that doesn't quite sound to me as if you got a name, you weren't sort of put on the child protection register. It may be that he should have ticked yes, but I'll tell you what, it's not going to matter, because you know where that's going to pop up? Safeguarding. So CAFCAS are going to be doing some safeguarding, aren't they? And the first thing they're going to do is go and look, number one, at the local authority and go, put the names in, pop, there you go. So there'll be records. So it will be noted, put it like that. It starts to frame the attitude of the people. People start to notice that kind of thing. And then the other thing you said is, do you think he thought I wouldn't get this? I don't know. That's the sort of silly Billy thing people do think sometimes, maybe. I don't think it matters. What I think matters is that you're prepared for the first hearing, and that you're particularly prepared to engage with CAFCAS in a positive way. And I think it's quite interesting that he's not had contact with the other two children, who I assume think psychologically he's their father, for 4.5 years. I think that's quite disturbing. And says a lot about him. And also, nobody's going to make them see him. That's like 100%. And I wondered was there a lawyer making bank and sort of pestering you into doing this? Because I'm sorry, but sometimes there are lawyers out there, aren't there, who are like, oh, I know what would be a good idea. It's like, yeah, just, you know, that just because you can doesn't mean you should.
Mm-hmm.
Right there. Anyway, that's my 2 penny worth. Maria, any other thoughts?
Yeah, I mean, I think that the C100 goes out as standard as far as the once it's been sealed, because you need to know why you're going to court. But yeah, whether or not I don't know if it makes it clear on the actual C100 itself. But
read it; it'll say.
Yeah,
I mean, it might be in the notes as well.
Blurb,
the notes are online, aren't they?
Yeah.
You will have also received an acknowledgement of service paper, which will ask you if you want an order yourself.
Mm-hmm.
And you might say, I'm not saying that you do want this, but it might be one of the things that you decide you would like. You say, yes, I would like the current consent order to be dismissed because it's not working for the children. Might be that. So don't forget to put, if you want an order, put that. And tell CAFCAS that you were a bit thoughtful about why he said there's been definitely no children's services involvement. Yeah, I think that's a bit odd. Yeah, that's what I think. That is what I think. Right, what's next? Let's have a look. Alrighty. Let's have a look. Elf said, yes. So section 7's been requested, but not safe if you ask me. Worried if I say no, they'll accuse me of alienation. Right, hold up. Okay. Right. I've got it. I'm now understanding Elf and how we do this. So, the question started off last Thursday, which was, hi, please help. I'm midway through section 7 and the social worker has asked if I agree to a visit with Dad to assess their needs. And I reckon we said yes, because I remember this question. We would have said, bloody hell, of course. I mean, what's the worst that can happen? And then what happened is Elf, basically, the baby woke up, so Elf didn't hear all of that and chip in with, the problem is this, huge domestic abuse. He was removed from our home in December 2025 for fear, threats to kill, firearms, ABD violence?
And violence.
And violence, thank you. CAFCAS did not advise contact while we had a non-molestation order. The NMO, non-mol, was extended just last month for further threats. It is a social worker doing section 7, and I'm terrified of them seeing Dad for the reasons above. Dad has been away from the baby for several months, and I'm terrified he will distress her or make W run, or maybe run with her.
Yeah.
Damn. So the section 7 request is not safe. And I'm worried if they say no, they'll accuse me of alienation. I say yes. A 14-month-old baby is going to get very distressed. They did a section 7 with us at home, then asked to put her in a contact centre to see him interact.
I don't think I phrased the question right originally. Okay, so is that done and dusted already? Are they still asking for a contact centre? I'll tell you what my instinct is. I hope the baby's not waking you up now, because I'd quite like to answer this. Can you just let us know if are you tuning in, basically? Are you tuning in now? Because I do want to answer this and I don't want you to miss it. And I might have some questions. So we'll come back. Okay, yes, you are. And she left. Okay, so the social worker left the question with you and asked how you felt. Maria?
I mean, surely in the initial, the findings that they do, they would have picked up that there's a non-molestation order in place.
What about this feels safe?
Yeah.
What about
none of this is safe.
What do we know about 14-month-old babies?
They're very vulnerable.
Yes.
And they need their mum.
And they need their primary carer. And if mummy is primary carer, they will freak. There's that window where you can just give a baby to the dog to mind shuts at about 8 months, right? At 8 months, human babies develop separation anxiety from their primary carer. It is a absolutely standard, predictable, unless they've had a knock on the head, categorically going to happen reaction. And the only time it gets messed with, and it is very bizarre to see, is children who have some quite serious attachment disorders, which is a result of that particular moment, generally when it doesn't go well. And they'll go to anybody, and they're people pleasers, and they're very, very, like, they're weirdly okay with any grown up that is vaguely nice to them. And that's when you see that in sort of 5, 6, 7-year-olds, it's quite bizarre, because it's super normal for small children up to a very, much older age to be shy around adults they don't know. And that's just a continuation of an 8 months old specific instant development of separation anxiety, where it's mummy or nothing, mummy or maybe one other person at best, and that person better be around them all the time. And even if they see mummy or the person they're imprinted on, that's who they want. I mean, it's very wearing, we all know. And at 14 months old, although exploration might be a little bit more embedded, and the separation anxiety may a little bit be starting to wear off with familiar people, that baby's not going to go, yeah, brilliant, yeah, all right, what should we do? Should we have a play? That's not what babies do. Babies just want to sort of gurgle and muck about with the people they know best. So I think there's two things going on here. Actually, I think there's one thing going on here. I think you've got a social worker who doesn't know what they're doing. That's what I think. And I think she wants you to make the decision, so she's off the hook. That's thing one. Thing number two, I don't understand her risk analysis, given she thinks it has to be a contact centre. And thing number three, I don't understand her understanding of child development and why she thinks this would be normal, natural. And she, as an observer, would get a normal, natural reaction from this baby to a man who's effectively a stranger to the baby, because that baby and that man have been separated for long enough in babyland for that to not, this baby probably won't remember him. I mean, and if she does, she might be distressed, and if she doesn't, she'll be more distressed. I mean, I'm like a bit like, sorry, what? So the social work doesn't seem very good. The risk assessment doesn't seem very good. And the could you make the decision so I'm off the hook, please, seems really rubbish. I think you should call it and say, my concerns are the significant domestic abuse perpetrated by him on me and consequently on her, because she's observed it, / on her because that's what he was like. Number two, I don't understand how you're going to get anything except a negative reaction simply because of her age and her stage. I don't think it's fair that she should be put through that distress, which is completely predictable, and which actually, in its own way, I'd accept isn't really to do with him. It's to do with him not being me. And that, therefore, no matter who you put up my baby with, she's going to scream her head off. And I think that's cruel for her. It doesn't get you, Mrs. Social Worker, what you need, because you're going to see a reaction that you might think is normal, and he's because he's terrible, or you might think is normal because somehow I've done that. I, the mother, have primed this baby to start screaming. She'll be screaming because she's 14 months and wants to be with her mum. And I'm not going near him because he's absolutely triggering as hell. And have you not read the safeguarding? So I think that's where I'd say if you want it to be like that, then if you want to observe him, you need to go and ask a judge. We can go and have it out in court. I think that's what I might say.
Yeah, I completely agree with that. It doesn't sit well with me at all.
It feels really off. It feels like a really bad bit of social working. That's what it feels like. Right, Maria, pick up. You do plays. You must have done some Dickens.
Well, we did Christmas Carol.
Right.
So, Marley.
Oh yeah, Marley. Good code name. Bang out the Marleys.
Let's have a look. Where are we? I'm lost. Okay, so this is a new one. So code name is Marley answering now. Okay, so Marley says, thanks, I have another question. Oh, so that's already got a code name. Well, they've got a new code name now. If my husband has... Oh, hold up. This is a two-part. So, okay, so let's start from the top. Okay. I want to submit a question for the 60-minute clinic tomorrow evening. My husband and I have been separated 2.5 years, and at separation we're married for 30 years. We were amicable and still share financial information, etc. If we have both been adding to our individual savings since separation when divorced and sorting our financial order, would whatever we both have at divorce be split or only amounts in our saving accounts at the time of separation? He is earning more than me, so he is able to save more than myself since we split. That's the first question. Should we deal with that one first? And then we'll go on to the next bit. Okay, so 2.5 years separated, married for 30 years. When did the divorce start?
I've got a sense that we've recently started the divorce, but the separation is sort of 2.5 years.
2.5 years, okay. And they've been doing savings accounts at the while they've been separated, but he earns more money, so he's able to save more. Okay.
Well, need wins, right?
Yes, yeah.
Necessary.
So Section 8 factors.
Yeah, Section 8 factors, and need is always top of list. If for some reason you need what you need, you'll get what you'll get. Nobody cares when it was produced. The other thing is, after a 30-year marriage, I think there's some slack in the concept that now my money is my money, if till you get your actual consent order done and dusted. And then the other thing is, I can tell you now that at the date, I'm not saying you will, but at a date that the court assesses you, if you were in court fighting this, the court would take the day of the hearing as the day of the asset pot. It may, so that's not the same as saying it wouldn't ring fence. Let's just say everybody had enough money. A court might say, well, I'm ring fencing here and here, even though I accept these exist, because I can, and I'm not gonna reach into that pot to level things up, because I don't need to, because everybody's got enough. The other thing a court could do is could say, I accept that this bit of the pot and this bit of the pot over here, these were all done post-separation, but this person has so little, I'm really sorry, but I've got to invade that pot just to level this person up a bit. And those are the options to the court. If you're trying to do this amicably, I think the first thing to always do is to compute, what are we talking about? We're talking about a couple of grand. I absolutely assure you, you could piss that up the wall on lawyers. and you don't want to do that. You really don't want to do that. So be proportionate about this, and proportionate mean think in terms of thousands, not hundreds. You know, walking away from 1,000 to 10,000 quid to get a deal is totally sensible. Totally sensible. So yeah, that's what I say about that.
And so Marley has a second question, which is, if my husband has recently consolidated his pensions, so therefore has a transfer value, would you advise still getting a POD to do a report? Married 30 years. She took a career break in 1998 and have only worked part-time since. Marley's only started paying into a pension again from the end of 2016. His transfer value is approximately 257,000. What sort of percentage claim, if any, would I have on those pensions? I have an old pension, which is saying is a defined benefit of 72,000, and a nest one is currently valued at 15,600. Trying to ascertain this to know if I could offset against keeping the matrimonial home.
What do you think?
There's a defined benefit pension. I know it's a smaller pot, but there is a £257,000 pension pot as well. I think a POD.
No, I think it's double. I think, if I've read that right, we have the 257 from him.
From him, yeah.
And we have
and then she's got
LDB 72. So that's north of 300,000 plus
the 15,600
grand.
Yeah, so we have a massive pension
350. It's about 350 grand's worth of pensions of various flavours.
Yeah.
Plus, you want to offset. Yeah, POD's worth it, isn't it?
Absolutely get a POD. Absolutely get a POD.
PAG would say a POD. So the Pension Advisory Group report, PAG 2, would say it's a POD. And I think if you'd said to me these are all defined contribution pensions, I would actually have said, well, basically it's just money. However, my instinct is POD, because there might be a couple of fancy stuff things lurking in these pensions. One is you're definitely in the age range for something called a guaranteed annual what's the GAR? Guaranteed annual return, I think it's what it's called, which means that the pension guarantees that it will never fall below a certain payout level. And those are in themselves quite valuable and more unusual, because they cost the pension companies a fortune, and they realised they had to stop offering them. And so that in itself might mean that the pension is more valuable than the CETV value, the face value. We use Simon Rieker. Maria, do you want to plonk his details in the chat or on the banner, on the jobby, the comments? I think Simon Rieker does really good pension reports there. He actually says, why would I make it longer and more wordy when I could make it shorter? And I think he's a very fair charger. So where you'll get people charging you £4,000 between you, he is more modest, and he's, he wants to be kind of affordable. And I think he's qualified. So the back of the Pension Advisory Group report says only people that have these qualifications are qualified to advise. And Simon Rieker absolutely is qualified to advise. So I would recommend him. And I would get a POD, and I would be asking some very simple questions. I would be asking him to advise on, number one, what is the equality of income on a 50-50 basis? Because you're entitled to 50-50. This feels like a 50-50 case all over for pensions. So I would be saying, number one, can you comment on whether these pensions face values are fair value? Are these fair market value? When we take 15,600, is that a fair market value? So that's question one. Question two is, please, can you give us the calculations for equality of income on retirement? And then it's probably age 67. I mean, you're in this zone where your retirement ages might be a bit funky, but I think I can't go any further than that. Let's say 67. please take into account our state pensions. You should say that too. And then thirdly, yeah, you're saying, can you assist us with an offset figure per £5,000 of house? How much pension should we swap off for that? There you go. That would be the basis of my letter of instruction.
Marley also says that they haven't started the divorce yet either.
Yeah, well, I think it's time to get on, isn't it? By the way, this all sounds very sensible and non-dickish. So you might want to think about using, I mean, unless you've just been incredibly diplomatic, but if you're all reasonable people, then think about a single solicitor service. I mean, obviously we offer that. Why spend twice as much money? And also the risk of one solicitor. And they're just out there. I'm really sorry, but they are just out there. What they do is they find a fine margin and blow it up, even though, again, honestly, I sound as if I fight nothing. I've got nothing but stuff in court. But £10,000, you just walk away from it, right? You just do it, because you cannot win that cost benefit ratio when you're using lawyers, even if it's unfair. And a lot of the time, particularly in business, people who are in business or people who are in their, say, 40s and 50s, actually, they'll make 10 grand in the blink of an eye just by not being in the middle of this divorce crap anymore, especially people in business. It literally is worth the money. Just, here's the money, goodbye, funeral first class, never want to see you again. And you get your headspace back. So it's a bit like dealing with a probate estate. It really knocks it out of you. Yeah. So that's what I've got to say about that. Yeah. What else have we got? Oh, okay. Ebenezer says, thank you so much. I truly appreciate your time, knowledge, expertise, experience, and frankness. What you've both shared was very helpful and reassuring to me. So this is the consent order about the 9-year-old with the other 2 kids. All right, we'll come back to you, Ebenezer, all right? Because I just want to make sure we get, blimey, we've got 22 minutes, Maria.
We've still got a lot to go through.
I've been gabbing. Yeah.
Yeah.
All right. You answer one while I pick a code name.
Okay, so let's go Martini.
Oh, Martini is back, is she?
Yeah, Martini is back.
Yeah.
Says, hello, only me, Martini. I have my fact finding coming up. Any advice? I am nervous about it all. On another note, I have filed my N208 application and it has been accepted. And we now have a hearing in September. What typically happens at this hearing?
What's an N208, please?
N208 is isn't that in Talata proceedings? An N208?
Is it a claim form? Is it like a Part 7?
Yeah, I think it's a Part 7 Part 7 application for costs.
Oh,
no,
is it? Or
I don't know.
Parts? You mean a Part 7 for a claim?
Yeah,
It's
a Part 7. It's a Part 7 application, an N208.
Right. Okay. So that's Talata. So yeah, unmarried, share a house, one person won't sell. I think that's yes. Part 7, you're in heaven. Part 8, it's a chuffing state. Part 7, meaning that if it's Part 7, this is how I remember it. If it's Part 7, it's just a simple make him do the thing that the written document says he's obliged and bound and signed up to do. A Part 8, if I've got this right, or have I got my rhymes wrong? I hope I haven't. Anyway, because this does work, right? Part 7, you're in heaven.
Yeah.
Part 8, what state? A Part 8 claim is where we're not just bickering over whether he should or she should sell the house. What we're bickering over is oh no, well, the house is in my name. Why do you think you've got a claim on it? Sod off. It's a whole trusts of land. Why, constructive trust, potentially resulting trusts. It's the works. It's the one that costs £1 billion. Whereas a Part 8 is usually Part 7 is usually make him do it, judge, and kick him in the pants while you're at it. And hopefully just the one hearing. if I've got 7s and 8s the right way around. If I haven't, just reverse the advice. Does that make sense? Anyway, carry on, because I'm busy thinking about code names. Sorry.
Okay.
This is why it's now only 20 minutes to do this.
So I'll go over that bit again. So on another note, I have filed my N208 application and it's been accepted, and we now have a hearing in September. What typically happens at that hearing? I have legal aid, so I've got a barrister for the hearing, and she will be asking him questions, but he has a QLR. He's convinced his grandparents to sign a false statement about an incident that happened where he threatened me. Do I need a draft order stating what I want the house to be sold? Ready for the hearing in September. I did attach all my evidence. Oh, I think we already answered this. Did we do this last week? This seems very familiar.
It does, doesn't it?
Yeah, because I looked up what an N208 was at that point.
That's right. We've had this conversation.
Oh, see, it's now Maria that's wasting the time. I'm so sorry.
No, I think. Right, I'm confuzzled.
Okay.
Which one are you? Right, hang on a minute. Okay, right, let's just figure this out. I've just got lots of lag with mine. Yes, we've done this, Martini. We did this.
We did do, yeah. Sorry,
Martini. We did this last. Yeah, sorry, everybody. We are silly. Back to Ebenezer. Ebenezer says that in spite of the fact we're clearly idiots, we're also very helpful and reassuring. Thank you for that. God knows we need it. Sorry, Martini. There was control and emotional abuse towards myself in the marriage. Yes. So this is the guy who made the old Children Act consent order a thing. Yeah. So there's control and emotional abuse to myself in the marriage, verbal and emotional and physical abuse towards the 2 eldest that he now does not see. I'm a very strong lady following a challenging couple of decades, but to hear that actually I may have been duped has thrown me a little. As you say, we are where we are. Kafkas will interview me and I can explain everything. I should say I had support from Women's Aid when we separated in 2021. They categorised mine and the children's risks as high. And you went into a Children Act order. I actually hate the system. How did it not pick this up? What is playing on my mind is how rare a children's consent order is when the parents have already agreed. I feel a bit scared of his motives now. And I'm annoyed at myself for that. No, just remember, this is not your fault. Let's just remember that when you have a shark biting your leg off, it's definitely not your fault. It's definitely the shark's fault. Okay. Predator's going to predate. That's how they roll. Can you recommend a Mackenzie friend in the West Midlands area? I spent upwards of 20k in solicitor's fee thus far, mainly due to his behaviour. Surprise. Lastly, let's end on a positive. My children are happy and safe. I am happy and safe. And the financial order has just been passed by court. Whoop, whoop. And the family home is ours. Good to hear. So yay, maximum props to you, because that sounds like that's not poo. Just a quick question. Is this the lad who's, this is the one who plonked in the C100 like she won't see it. Please tell me that you have sent a C1A into court. If you haven't, now is your time. Yeah. All right. Make a C1A is where you set out your emotional abuse and your physical abuse to the children. It's totally relevant, 100% relevant. Could somebody be very kind and look up the wheel of power and control? Because you can never have that wheel printed on your fridge too often, because it will give you a level of, and actually you've done some Women's Aid action. Hope you've done the Freedom Programme. If not, go and do it. Do it more than once. Why wouldn't you? And it's about articulating what the violence was. And remember, ChatGPT is probably not your friend at this point. It's about saying, he did this, and here's the impact. Here's who I told about it. It might be, I told my solicitor. What do they do about it? They wrote him a letter. Or I told social services, but they didn't take it very seriously. Those are all okay things to say in a C1A. It might also be, I didn't do anything because I didn't realise it was abuse. Totally respectable answer in a C1A. But try and articulate what it is that happened. And I think there is huge relevance of him being shitty to your other children, immense relevance. Mackenzie friend in the Midlands area, I'm gonna put a word in for Michaela Wade. I have, for reasons, seen her in action, and I think she's probably as good as a solicitor who actually knows what they're doing. There you go. It's very stupid of me to give somebody else all my work, but I would say that Michaela Wade, who probably has a website called michaelawade.com, is wherever she is. I know she definitely does London, but the Midlands is not that far, is it? I mean, Americans laugh at us. They say, I was with some Americans yesterday for one of my bizarre diary incidents, and they said, for you guys, 100 years is not old. For us, 100 miles is not far. And it's just such a difference, isn't it, in the way we all think of, like, we're like, oh, Birmingham. Yeah, it's quite far away, isn't it? Actually, it's not. So, yeah. So anyway, Michaela Wade, can recommend. Don't know if she'll go that far, but hope she will. And great that your family home is yours. Good for you. And don't be annoyed at yourself. It's just all part of the learning process. You know, if you have your own pet narcissist, it takes a long time to read the manual. That's really all I can say about that. Right, onwards. Okay, hello. And your code name is Defarge, right? So, Defarge, I'm going to answer you now. Ooh, Defarge says, I'm on my second gatekeeping hearing in Pathfinder. They should so have kept that name. Everybody's like, yeah, Pathfinder. And now they're calling it Child Focused Courts just because the Tories invented Pathfinder. So we've got to call it something different because we're Labour. Genuinely, that is poop. Anyway, Pathfinder, as everybody's really calling it. September, something about September. It's about my 15-month-year-old. My ex filed a C100 to get the child in nursery, having unilaterally moved cities. Oh, I've done a C2 to look after the child, as have permission to go part-time. As a result, the ex is not working and paying to reserve the nursery place, so high stakes. After CAFCAS, the judge could make an interim decision. Is this likely? How would a judge look at this? Having a child regularly and staying overnight. My ex has also been making unilateral decisions. Should I tell CAFCAS this and illustrate this? My ex alleged emotional abuse has a C1A, which is very vague, and I can disprove it in email. Should I give this to CAFCAS? Thanks. The gatekeeping is behind closed doors, so we can't attend, worried about a status quo being created. No, I don't think they will make a gatekeeping decision which creates a status quo at this point. They'll have you in, I would say. And your ex basically wants me not to access the child during the week. So she wants to work Monday to Wednesday and care for the child on Thursday and Friday. And it creates a situation where I only see my child every other weekend. The C2 was for shared care. My child stayed over regularly and I saw my child often. Okay, so if we've got that right, you had lots and lots of care. This child is very young, 15 months. And the problem is your ex is basically going, well, that's all done now. So now we're going to standard weekend dad arrangement. Well, I think one of the things that will be absolutely crucial for you is to think about moving closer. And what's the distance between you? Because I'll tell you what won't work on shared care is when a kid gets to school. They're busy being at school and they need their parents, if they're sharing care, to live closely. And it may well be that a judge says, well, this child is really used to living with both of you. But I think a lot will depend on the emotional abuse being bottomed out. And I think it's really important that if there's a C1A, you answer the C1A. So at the end of a C1A, if you look right on the back page, there's a page that says something like, what, in brief, and it does mean in brief, what do you say about the allegations raised against you? And it's really, really important to fill that in and send it back to court and say, you might just say, I deny this, or I disagree with the way that it's being explained. We had our difficulties, but it wasn't emotional abuse, just to stand up for a position. So I think a lot is going to depend on that, and I think it's important that you get in writing what you've got to say about the C1A in front of the court as soon as possible. And by the way, be really prepared for CAFCAS not to have those documents. So make sure that you say to them, "I've done that. Have you seen it?" Yeah, I would be very, very surprised if gatekeeping established a status quo, and I think that would be appealable, by the way, because it's such an obvious final-ish kind of outcome without any due process. By the way, if you ever have to appeal an interim order, like a gatekeeping order, which I stress would be unusual, you'd need to do that in 7 days, not 21 days, and the timings tend to be very, very strict. So that's what I've got to say about that. And, keep checking in with us. We'll help you as we can. So there we go. What is next?
So Bulldog has got some questions regarding an FDR that they've got coming up, which is an old one. I can see George's name in there. Still Bulldog. Okay, so Bulldog says, I have a couple of questions regarding FDR and the offers proposals that they put before the court. Firstly, are without prejudice offers proposals put before the judge at the FDR, or is it only open offers proposals that are provided to the court? If the matter proceeds to a final hearing, are the without prejudice offers that were considered at the FDR excluded from the final hearing? Where did it go? It jumped. Why did it always jump?
Oh, it's me. Sorry, because I'm mucking about with it. Yeah.
With only the open offers letters being put before the final hearing judge. Secondly, I would like your opinion on what would be the most sensible position for us to put forward in an open offer. We previously made a 73-27 without prejudice offer, which he rejected, saying that 27% would not give him enough money to furnish the property. He has now come back with a 68-32 offer, but this does not meet my needs or those of the children. My solicitor has suggested that we make an open offer for 80%. 80 to 20 based on the declaration of trust. The declaration of trust was entered into approximately 4 years before the marriage, after I sold my own property, which was wholly mine, and contributed 97,000 towards the current property. He has no financial interest in my previous property. A solicitor I spoke to yesterday also suggested that the 80-20 position should be put in an open letter, despite the fact that we had previously offered 73-27. I'm concerned about my ability to rehouse myself and the children. I'm on a low income and can only obtain a mortgage of around 15,000. I also have a daughter with chronic fatigue who is currently on a reduced timetable at school, so I cannot increase my working hours to improve my income. I also have significant other financial contributions to the property and household. In these circumstances, would you consider it sensible to put forward the 80-20 position as an open offer based on the declaration of trust and financial and housing needs, or would it be better to maintain the previous 73-27 position? I would particularly appreciate your view on whether without prejudice offers are shown to the FDR judge, what happens to those offers if the matter proceeds to a final hearing, and whether putting the 80-20 position as an open offer is strategically sensible in these circumstances. Thanks. Okay. So without prejudice offers are they are in the bundle for an FDR hearing. And they are considered at the FDR. The point of the FDR is in order to try and reach a settlement if you can without going to final hearing. The without prejudice are not in a final hearing bundle. It's open offers that are contained within the final hearing bundle, in order for them to be considered by a different judge. So your FDR judge and your final hearing judge will be two different judges. It can't be the same judge that deals with your FDR. As far as an 80-20 position is concerned, I'm going to need your help on that one, Ursula.
I think that sounds quite sensible. I mean, what you're saying in that 73-27 and 80-20, what you're saying is if you settle now, mate, you can have more money. You have 3% more. Right? Whereas no,
it's 7% less. He's getting 7% less.
80-20. 80. So sorry. Is she saying I'll take 80% and you'll take 20% if you make me go to final hearing?
Yeah. Well, that's what other people have advised.
Yeah. And she's saying that without prejudice, she's saying I'll take only 73% instead of 80%, and you can have 27% instead of 20%. So he's getting 7% more.
Yeah. On the
but
yeah,
only,
27, yes.
only if he takes it at FDR.
Yeah.
So that makes logical sense to me. The idea is that it should get more expensive for people if they keep going. Your open offer should not be your best offer. It should be backed up. I mean, I think there's much less margin now. It shouldn't be toppy and bonkers, but it can be toppier than the without prejudice offer. So that seems like the right way around to me on what I know. I think, so I think that does make sense. And as Maria says, without prejudice is in the bin at the final hearing. So nobody ever knows you made it, and it's not allowed to be referred to. I mean, your rationale for your offer is sound. It doesn't meet your needs. And I think that you're entitled to say, if 80-20 meets his needs, given that you're basically saying that £97,000 in the current property, and probably more if it's gone up in value, was undoubtedly non-matrimonial, right? It's a standish point, that this is not a fruit. This house is not entirely a fruit of the marriage. And firstly, if his needs are met, do you remember what we spoke about right at the beginning? We were saying, if there's a ring fencing argument, which effectively you're making, you're saying, got a declaration of trust. And the use of that declaration of trust is it absolutely cuts out exactly how much money we're talking about. That's its main use. We all know that the Matrimonial Causes Act can override a declaration of trust. You get married, you could be sharing. But at least what your declaration does is it says exactly this much money was what was not in the marriage when we started, and it's been brought into the marriage. There'll be arguments about how you've mixed it with a matrimonial asset. I know that. There'll be a load of waffle about whether there's matrimonialization. But essentially, this sounds like a needs case. And because it's a needs case, even though your arguments are sound about ring fencing, needs is going to be the overriding way that a judge looks at that. So if your needs aren't only met with 73%, then I think a judge would approve that, and a judge would say, and you're a smart cookie for walking away from some money just to make this stop. If his needs are thoroughly met by 20%, and he's got everything he needs because he works more, so he's got sort of like a better mortgage capacity, plus that whole standish declaration of trust, ring fencing argument, I think you've got to shout at saying to a judge, well, why should I share? He's walking off with his earning capacity and I'm not. So because of our daughter, and I'm the primary carer, and actually that's going to piddle all over my future earning prospects. So I just think you've got a good argument. I mean, of course, it all depends on the day. And I go back to what I said earlier, which is, if it costs you 10 grand to walk away, you bloody well walk away for sure, if not more than that. But yeah, I think it's sometimes where you're in a hard needs position, you're in a hard needs position, and you might just have to be ready at an FDR to walk away. With an FDR, it's very helpful if you understand how much money it will cost you
if you go to final hearing, because you almost certainly won't get any of it back, and you might get some of it back. You probably won't. So that's your litigation cost going forward. So don't forget that, and know what that number is, so that you know what it will cost you and what you'd be walking away from if you do that, if you see what I mean. So yeah, so that is what I've got to say about that. Does that answer your question? Does that help? And I hope you've got a lawyer. You need a lawyer, especially at the FDR. For God's sake, take somebody with you at the FDR.
Yeah.
Right. I wouldn't want to do an FDR on my own if I wasn't a lawyer. Oh, and just back to Defarge. You lived together for 11 months and you're only 22 miles away from each other. That's not that far, is it? That's kind of certainly on the edge of shared care. It'd be much better if you were in the same town. If she's settled, you might if it's in your ability to say, if the court orders me that shared care would be in my child's best interest, I will be moving. That would definitely help you, Defarge. So I think right. Don't know about you, but I can see that it's 2 minutes past 9.
It is indeed.
Good. I am absolutely pooped and knackered. We're going to have to... oh, gosh. We ran out of time. I'll just put this. Sorry, we ran out of time. Next week, promise. Okay. And also oh, I'm so tired. Who's that other one? Ooh, oh, bloody hell. Poodle. We're pooped. Oh. We might need a play as you go about that.
Mm-hmm.
I'm really sorry, but I am knackered and it is 3 minutes past 9 and I haven't had my dinner. So if that's all right, have a glass of wine. Yes. Thank you for your medical advice. That's what we shouldn't be doing.
Might need it though.
Yeah. Yes. Anyway, yes, it is a full day's work when we do this. So thank you everybody for tuning in. Thank you if you've been watching back. It's always good to know that people do watch back. Sorry if we didn't get to you. We've had a lot of questions tonight. So yeah, I think it's goodbye from me. And don't forget, you can catch up with this if you need. And like and share and let people know in your groups about us. We are more than happy to help as many people as we can in an hour, and the more the merrier. So it's
don't forget you've got Rebecca tomorrow, next week as well.
Next week, Rebecca next week. So yeah, new faces coming in. You're right, me and Rebecca next week. That's right.
Yeah.
So we'll see everybody next week. Thank you so much, and goodbye from me.
Goodbye from me.